Hey guys, let me bring the chat up over here. So anyway, just got off this other stream and was looking to see if Sarah's letter that she wants everybody on the planet to read had been posted, but found something maybe more interesting, or at least more informative. Maybe interesting wasn't the right word, but let's look at it. And I'll stop talking about it and show it. So we know that her case was continued. Her attorney saying, look, we need to help with money for an expert for this battered spouse defense, and the hearing set for September 18th. The case nominally set for trial for October 2nd, but with defense agreeing with judge, we're not doing that. We're just setting that in the system. So this case is way out. Anyway, a filing just occurred that I saw, an answer by the Justice Administrative Commission on the motion for appointment of defense forensic psychologist. So let's look at this because this is quite interesting, I think. The idea being that, of course, she should be allowed to have an expert if she wants to pursue this defense and has some reason to do it. I get that. That's fair. I think we all can agree it's fair to at least let a defendant pursue some of these defenses if there's a credible basis. I don't think she has that here, but she is on trial for a substantial penalty. So tie goes to her, but let's look at it. So let's get this information out there. That her lawyer is seeking an additional authorization for $15,000 at a rate of $400 an hour and $125 for travel time for a defense mental health expert. So that's above their rates they'll talk about. And he's asking for that to be exceeded so that they can get this person who they've identified saying, that this individual will testify about this, I guess. But there's a bombshell in this, I think. Based on JAC records, the court previously appointed a mental health expert to assist the defense, albeit under a prior indigent for cause counsel. JAC paid $7,500 for the services of this expert for services rendered from August 21st, 2020 through April of 2022. So apparently they did have a mental health expert appointed for her, and I guess they didn't get out of that what they wanted to get out of it. And now they need this new person for $400 an hour and twice the authorized money of $15,000. Now, JAC says, listen, we can only pay due process costs as authorized by statutes. That's what they're there to do. And, I'm going to move your screen up here so I can't see the chat while I'm reading this document, but now I can. All right. So, okay, let's go here. Now, thank you for your comment on Brooks. I'll come back to that, but let me get back into the game here. Oh, I can't do that from there. Yeah, that's what happens when you do these pop-up streams. All right, now I'm back in the game. And they put in bold here, JAC objects to any compensation rate in excess of established rates. The rate for a psychological examination is a flat fee of $350. For other services, here are the established rates. And they say we'll pay somebody $170 an hour for a court appearance. If they have to wait around, they get $85. And if they're traveling or a deposition, $72 an hour. And if they're doing things out of court, $160 an hour. And they have spent, they said, $7,500 on somebody doing something for this already. So I didn't know that. Maybe other people knew that, but to me that was interesting. Like, yeah, okay. Do you need an expert, or you need an expert that says what you want them to say? I don't mean to sound biased, but I am biased. All right. So counsel, talking about her counsel, has a burden to establish the particularized need for expert services and necessary for the defense of the case, and a burden to show diligent efforts to obtain services within or closer to the rates established by law. Okay. So the right to have assistance of experts in your defense is not unfettered. The right is limited to experts that are relevant and necessary to the defense of the case. The defendant is not entitled to a specific expert or one of his or her personal liking, but is only entitled to the services of a competent expert. So was there a mental health expert earlier in this case who gave an opinion that would not be useful for the defense in this case, and that's why they need somebody else? They're going to have to speak to this, I think. Did that person move away, and so you can't use them anymore, and now you need this new person? I don't know why you need a different person unless you need a different opinion. But they could have a reason for that. They're going to have to respond to this. But this is new information to me, certainly. So let's see. The determination of whether to appoint an expert is within the broad discretion of a trial court, which is most things. And you have to show a reasonable probability that the expert would be of assistance to the defense and that denial of that person would result in a fundamentally unfair trial. Counsel needs to establish the need for an additional mental health expert, and that word additional to me matters a lot. Like, okay, the taxpayers have paid $7,500 for your ridiculous assertion, potentially, that you were a battered spouse. Now, I don't know what the first mental health person did. Maybe she was going to try to say her mental state wasn't good or whatever. I'm not sure, that would have done her much good. Saying that she was drunk because it's not really a defense, voluntary intoxication. I don't think it could be for intent, but for reckless, I don't see it. I have to go back and look at the law on it anyway. So they're saying, hey, look, you want a new additional mental health expert, a second one. Where the court previously appointed an expert to assist the defense. And it says the expert conducted an evaluation of the defendant. So according to their records, this mental health person, who they say they paid $7,500 for, did an evaluation of Boone. Okay, so if that person looked at Boone and said, hey, she was a battered spouse, then why not use that person who apparently was operating inside the rates of the JAC? And now you need a person who is way higher than those rates, right? So up till now, I'd been listening to defense counsel say, which I hear what he's saying, I can't get somebody to testify at the JAC rates. And that's a problem potentially. But if it's, I can't get somebody to testify to what I want them to say under JAC rates, that's different. I'm not here actually accusing this new person of, say, being on the take for extra money. My point is, if you've got experts in the area who work within the JAC rates, but they don't say what you want them to say, it doesn't necessarily mean the taxpayers need to be on the hook for you to search the country to find somebody who may have a different opinion, even if that opinion is in good faith. Is that really on the taxpayers just to find the most expensive person you can come up with? So I don't know about that. I think perhaps not. Just interesting. I haven't heard this discussion before. The state is only obligated to provide the basic tools of defense and does not require the due process, does not require the state to provide every foreseeable service to the defense. And then it talks about the United States Supreme Court. They want to be able to provide an adequate opportunity to present their claims fairly within the adversary system. Now, I can tell you, as you probably know, that does not mean unlimited budget for everything that you ever wanted in your entire life. Neither side has that. And sometimes defense is more constrained. I'm sensitive to that. Like I say, I hear what he's saying. If he can't get anybody to testify within JAC rates, that is different than already having had an expert do this and now wanting a different one, at least in my own practice. There can be more than one reason for that, but one reason is you didn't get what you wanted out of the first one. They can be. You don't think they'll be credible to the jury. They may have moved away. There can be other reasons, but often you go to the next expert because you need some different testimony, a different view of the case. I'm not saying it's bad faith. I'm saying a different view of the facts. In light of the services already provided to the defense, her counsel has the burden to show the need for a second mental health expert in this matter. Although counsel may prefer the services of a preeminent expert, due process does not require the state to provide services that a wealthier defendant might like to purchase. In other words, just because you're on the public dole doesn't mean you get to go shopping for the most expensive people on the planet, wherever they may be. That's not a carte blanche to just do whatever you want to do. If the expert who has already evaluated the defendant can provide competent and meaningful services to the defense, the court should not appoint another expert in this matter. And I think the burden the defense would have there is if the reason is, yeah, but that expert didn't say that she was suffering from the syndrome and I need one who does. I don't know that that's going to persuade the judge to spend a lot more money. It needs to be something else, like that person can't do anymore or they refuse to do anymore because of this, that, or the other. So counsel has the burden to show diligent efforts to obtain services within the rates established by law. JAC would not anticipate paying a rate in excess of $200 per hour for a defense mental health expert. Even if there is a specialty, it wouldn't go over $300 an hour. And then they talked about what to do if you think you need somebody who's higher than the rate, and a written motion, which I guess is what they're doing here. And of course, her side of this so far, her primary motion, that's under seal. and it probably has some details in it that, aren't suitable to the public, or at least that's what her side thinks. They will be, normally you have a motion, you have a response to it, and you can have a reply. So her attorney will be able to write a reply to this, may or may not put it under seal. This would be argued in September 18th. If attorney intends to procure due process services rates higher than the established rates, file the written motion. You have to show diligent effort, due process. I think a hole in this diligent effort thing is the fact another attorney did find an expert who was not problematic to JAC in terms of cost, and JAC paid for that expert. And now you want a new expert at more than double the rate that JAC, more than twice the rate JAC normally pays. So I know they said in court, JAC hasn't adjusted their rate in 10 years or whatever. But does that mean a more than 100% increase in cost? Let's see. Due process is necessary, etc. So if any due process vendor desires direct payment, you have to do all this stuff. And all the documentation is needed. Just give it through some of what it looks like, paperwork stuff. So JAC requests this matter be set for hearing, and they want to appear through communications equipment. And they can be reached toll free at this handy number. So they request the court, should it grant the motion, also include in the order specific due process services authorized, as well as hourly or per unit rates and maximum fees approved. So they don't think this second expert should be authorized, and they don't think if it is authorized to have this person, that it should be just do whatever you want to do, that there has to be task limits and scope of service and maximum fee and stuff like that. So that's it. There's a lot more pages to this, but it's a JAC contract, which might be why some of the other stuff is so long that's under seal if it had that, because it's like 30 pages. So my idea when I got off the other stream was to just glance at the docket before I did other things, see if this letter was posted. And it wasn't, but this was. And this is more informative to me because it sets out I understand her attorney's position, which is we cannot find an expert at the JAC rate. We do have an expert identified who's willing to work this case, but at $400 an hour when the rate is $160 to $170 an hour for JAC. So I hear all that. But the problem with what JAC is saying in terms of the defendant's argument is that they already hired somebody apparently at the rate or within the scope of what they would approve, who they spent $7,500 on spending time with Sarah and giving an evaluation. And apparently she's not wanting to go to trial with whatever happened with that. So I don't personally see how you can come up with the idea that she was a battered spouse at the time that she did what she did here. I think the charge of reckless is appropriate. I don't know that you could say that she actually formed an intent to kill, but she engaged in reckless conduct. To me, seems very reasonable to say that she was a battered spouse here. I don't buy that. But to try it potentially with the first expert and then not get there and then need another expert is stretching it, I think. So I think the defense will have to say, oh no, the first one, they didn't talk about battered spouse. They only talked about how drunk she was and her mental state and things like that. But I don't know. This doesn't look good for the defendant's argument, in my opinion. It does look more toward what somebody was saying on the panel earlier, which is they feel like Sarah's been told by other lawyers battered spouse isn't going to fly and she won't agree with it. And so they're trying their last effort at seeing if they can get somebody to move this defense forward for her. But if they already had a shot at the apple, the law likes the phrase, one bite at the apple, you don't get to keep coming back, then this doesn't look good for them. All right, let me check the chat, see if you guys have anything on this. If this letter pops up, I got a thumbnail ready, so we'll definitely read it when it comes out. But I agree, $350 flat for a psych eval is really low. However, remember in this case, the first expert was paid $7,500. So they weren't limited to just doing that. They were able to do other work, and apparently they did. So I don't know that it looks too good for hiring this $400 person if you were able to get somebody at the lower rate. Let's see. Checking to see any news on this stream or any questions to answer. $400 an hour. I'll say whatever she wants me to as well. Yeah. I'm not going to go there all the way with this expert, although I've been calling him bozo and clown and stuff, because I I do not perceive how this defense is applicable here. But maybe they found somebody who sees it the other way. And it costs money. Sometimes a private person, maybe who doesn't do this often for the government, so that's not the kind of rate they normally have. It could be somebody from a place, I don't know who the person is. Let's say they're from some major city somewhere out west in LA or something. Maybe $400 an hour is a more reasonable rate out there. And if you want me to come to Florida, you got to pay what I normally make, or I'll just stay here and make it. That could be the case too. The expert could have offered such a rate to avoid having to do it. I mean, I think, the other answer is I'm just not going to do it, because he did say that he had contacted multiple people and he wasn't having success. So I think some people had said, nah, I'm busy, or nah, I'm not going to do the JAC rates and stuff like that. He did tell the court that I have someone who will work this case if they're paid this amount of money. And for all I know, the judge is going to say, yeah, I'll pay that. So if you don't want to work a case, same thing with a lawyer, do not agree to work it. That's the best way to avoid working on it. So here's a question. I thought the problem was the court didn't cut a paycheck, not that the expert doubled their hourly rate. So the way I understood it was, and I'm not saying the docket doesn't have some of this information earlier, but at least as I was perceiving what was happening recently, is they fairly recently said, we want to do battered spouse defense. And then this guy says, look, I'm trying to get people. They had a continuance by defense for that matter. I can't find anybody who will go JAC rates. And if they did find somebody to go JAC rates, they probably would have gotten that handled. So I don't think it was that the court wouldn't cut a paycheck so much as it was he was saying he couldn't get somebody to work for those rates. Now, what he did do was say, look, I went out and found somebody who will work for this rate, and the court can consider it, and JAC can disagree with it, as they've done here. The bomb in this, I think, is that they already did have a mental health expert that they spent $7,500 on. So, what happened there with that person and all that? Like, why can't you keep using them? You can speculate your own answer to that. I already told you what mine would be. Does JAC pay the same rates for the prosecution is the question. And, I don't know that in Florida, because I barely know this JAC even exists there. That's a fair question. It might come out. We'll look and see as well. So now, if she does get this second expert, the state will be able to get an expert too. And we already talked about how that would work in terms of scope of what the state's expert can do. Depends to some degree on what her expert does. If the defense attorney can't find a specialist to say what he wants, can the judge appoint one that will accept the $7,500? Well, the judge isn't out there shopping these people, and they only presented one to the judge, and that's the $400 an hour person. And that's it. It's not the judge's job to figure anything out like that. And apparently, though, the court did earlier provide money for an expert who gave some form of evaluation. And I don't know what that is. But if that evaluation was, I am confident that she is suffering from battered spouse syndrome, and I am willing to come to court and say that, then how come they're not using that person? So I'm getting some news that audio is choppy. Don't know why that is. Maybe I got too many browsers open or something. As I flip this on as soon as I got off this other stream. All right, so were they living together? If not, could she still claim battered spouse? Battered partner is also what it's called. And I guess I'd have to look at their law in particular to see whether you have to be living together to claim it. But I'm going to say no to that. But that does matter, because you could have potentially a duty to retreat, although they've changed their law famously down in Florida. I'd have to go read it. But in the old days, there was an issue with battered spouse stuff because you had a duty to retreat. And if you're in your own home, what are you going to do? Well, they took that away and said, if you're in your own home, you don't have to retreat. So, in theory, if you're going to visit somebody and they start attacking you, and you can just walk right out the door, you're supposed to do it without shooting them. But on the other hand, they have stand their ground and all that. So I think that has changed the law down there some. But I don't know that it's a requirement that they actually be living together at that moment so much as it's a requirement that, it's not a technical defense in the sense of written up in the law like that, so much as it is a court-created way to establish a normal self-defense claim. That's how they do it in Florida. Every state can be different. It can be statutory in some states and things. And Florida, I think, has put some of its self-defense stuff in statutes and changed it recently and all that. But the idea is battered spouse part of it is if you're going to use force against somebody, especially deadly force, then you have to be in reasonable fear of imminent harm. Okay. A serious imminent harm or death. So if somebody says, I'm going to shoot this rubber band at you, and I pull out a 12 gauge shotgun and kill them, they were going to assault me, cause some level of harm to me. Is blowing them away with a 12 gauge shotgun a reasonable and proportional response to that threat? It's not, right? But if the person pulled out a 12 gauge shotgun and pointed at me and said, when I count to 3, I'm going to pull this trigger, and then I pull out my gun and shoot them, I got a pretty good case that the threat to me was serious bodily harm or death and imminent. If somebody comes up and says, man, if I come back to this town 5 years from now and you're still here, I'm probably going to do some serious damage to you. And then they leave, and I think about it, and I go to their house that night and shoot them. I'm not in any imminent threat there, right? So the battered spouse part is the abuser doesn't have to be attacking you in that moment when you use force against them, which normally would be the case, right? And you're saying that this person is suffering from a syndrome, that they're under such fear from this other person that it is reasonable for them to believe that they are in imminent danger of serious bodily harm or death, which I do believe in that. So I'm not suggesting that I disagree with this defense in general, because I do not, because there are some people who put that level of fear and control on somebody by the use of violence. And if the only way you can escape it is when that person is not on their guard is to take your shot, then I'm down with it. You do that. So if somebody, but you're going to have to show it. Okay. You're going to need to make that defense out. But if that person did that to you, they get what they get. Let's see. Expert or not, they were not fighting. She did not have to defend herself. He was locked in a suitcase while she goes to bed. So yeah, now on the facts of this, I think the idea that she was suffering from battered spouse syndrome is laughable. How I conceive the syndrome, which is not, you're drunk, you put the person in a suitcase, and as they beg for their life, you laugh at them and then you go to sleep. That's different than, the woman who's been beaten severely and threatened and all that stuff, shoots the guy in the middle of the night because it's the only chance she has against him or something like that. If she were really scared of this guy, why would you leave him in a suitcase where he might get out of? And then if you were terrified of him, he would be the maddest he's ever been at that point, but you're up there sleeping. So none of it makes any sense to me. Perhaps it didn't make any sense to that first expert either. Sounds like the same rate for Letitia's shrink. Maybe. I didn't think much of that either, personally. It sounds like my boss quotes a high retainer for a case they don't really want to handle. I hear that, but this isn't like building a sidewalk or something like that. Like, this is going into court and giving an opinion, a professional opinion, and it shouldn't matter whether you're paid $1 or $1,000 an hour, whether you're willing to give that opinion or not. Like, if you're not willing to give it, then don't do it, because it's $400 an hour worth being embarrassed over if you don't believe in what you're saying. And ethically, if you don't believe it, then you should not go into court and testify to that, right? So, if I can't stand a client and think that I cannot represent that person zealously, I'm not taking their case. Even if I hate them, but they have a lot of money, they deserve a lawyer who will do that. And if you can't bring yourself to do it, you shouldn't do it. So now, I'm not saying that what you're saying never happens. I'm saying that's not the way it should be approached, right? What if the new expert's findings don't agree with the defense either? Yeah, I don't know the answer to that, but I'm thinking that perhaps they've already talked to this expert some and feel like that they're going to be in sync on this, but maybe not. It's a good question. Either she tricked him into getting in a suitcase with a game, or she forced him in there by some other means. And yeah, it seems to me like he went in there voluntarily, because it seemed like he was tired of being in there and thought this game's over. And she's like, oh no, this game's only begun. And of course she told the police, oh, I thought he could get out. He had room for his fingers and stuff. And that's all contrary to the idea that you're under fear of imminent harm, right? So that's crazy. So you're going to have to say, well, I was lying to the police there because I remained in fear and I didn't want to admit it. And I didn't know my legal options. It's all crap. So she should have come to an agreement with the DA on a lesser charge. Well, yes, but that assumes that the DA has said, hey, we'll just give you manslaughter if you'll plead guilty. And I'm not aware that the DA has said that yet. And really, the DA's case is extremely strong for reckless homicide. So maybe the DA hasn't offered that yet. The DA may have said, but I'm not saying that they did, that if you plead guilty to the right thing that you're actually charged for, we will work with you on sentencing or something like that. You know, I don't know. I'm not aware of any negotiations going on to this point. Now, granted, if you could come up with an expert who would say this stuff and you did want to plead to something, that would give you some leverage against the state. But I'm not sure that the status of any plea negotiations that they have or may have had. However, I agree with your sentiment that if she could do a plea bargain to some lesser charge, she should do it. And especially if she got a lesser charge. I mean, she's already been in prison for quite a long time, so she's going to get time served credit. Language in the statute needs to change. Well, yeah, I can't remember what it actually said in the statute. That blurb I showed this morning was from an article, and then I did quote the rule. So it's a battered spouse, battered partner. So I think it is kind of more gender neutral in that regard. The article was not, but this is. And of course, when it was being created, it was a gendered situation. It was, you know, battered wife syndrome and all that. And maybe that's where it needed to start, because with those kind of cases, you could see that being true in some cases. There are some people who think, oh, no matter what the person said and no matter what kind of torture they inflicted on somebody, if they're not attacking you in that moment, you cannot do anything to them. And I think that's the right general rule, but I think there are exceptions to it. That's what I think. And when you think you have that level of power over somebody, I can tell you that I saw that in the Army once, where the word went out to certain people, everybody has to sleep. And even the biggest guys got to sleep. And so if you're a terror during the day, you may find something visit upon you at night that you didn't see coming. So the battered soldier syndrome, as I've seen that happen, where they fight back when they're ready and can do it. So nature has a way of balancing it out. I like it. Only shows you can buy an expert you need. Yeah. I don't know what this new person would say. So I'm with you on the cynicism, because rarely do I see a case where you can't get an expert on each side saying exactly the opposite thing. That's just how it is. So I hear you. But I don't know what this expert's going to say if they are hired. So who knows? No duty to retreat out of your house, although that did used to be an issue if you could retreat. But now there's not, and I think the stand of ground thing probably changed it even more than that. I hope it's not the same person Letitia had. Yeah, although that lady, Dr. Which I'm doing some of those myself right now, to me was a thoroughly unconvincing expert. So if you are going to waste this money on somebody, that would be a good one. Let's see. She offered any kind of deal from the DA. Not that I'm aware of. Doesn't mean it hasn't happened. And I'm not an expert on her docket, but I've been watching it for a while. So I'm waiting for this letter. And that lady was as crazy as her client. And there, I assume you're talking about the Letitia case. Remember, her son was in the room? Okay, what's up with that? That was a little crazy. Yeah, so here's a comment. I think it was Sarah's lawyer said nobody really wants to be connected with this case. And he kind of did say that. But, you know, they have got somebody connected to it who they spent or were allowed $7,500 on. And now they got a new one who's willing to be connected at $400 an hour. And they want $15,000 for that. Any word on the Marilyn Manson case? So, of course, there were anonymous letters sent to the court. And Manson said, I'd like you, court, to publish those in public. They were against Manson, but he said, I want those published. The judge said, if the defendants object, I won't. And they did not. So I suppose those will be published. So there's some speculation on who sent that being involved in the case. I don't see that. I see a lunatic away from the parties, but I don't know. Whole generation that missed out on the Bobbitt case. Yeah. Yeah, I don't think she thought she would kill him, but she had no problem basically torturing him. And it's, like a reckless indifference is what she's charged with. So when she was in her interview with the police or interrogation and saying, I didn't mean to do it and all that stuff, not relevant to the reckless charge. You didn't have to form the intent to actually kill him, because that's not what they were going to charge you with. So she thought she was outsmarting them, and she did not. There was no imminent danger if he was locked into a suitcase. Well, right. But the whole battered spouse thing is, maybe getting him in a suitcase was the only way you thought you could cause violence to him because of his prior imminent threats. That's the whole thing about battered spouse, is you're not being attacked at that time. If she were going to claim this, it would have made a lot more sense to me if she got him into the suitcase, locked him into it, and then took off. It gets harder to claim that you're acting in self-defense when you put them into the suitcase, make fun of them on video, and then go to sleep for hours and they don't get out. And that doesn't add up, does it? Let's see. This woman smuggled herself out in a suitcase to the West. Yeah, there have been a few people who managed to suitcase their way around. Let's see. Experts should not be able to project their testimony without the avowal first. Right. And so I'm merely saying here, I don't know. Right. I don't know if this person read the other evaluation and said, well, based on the facts of that evaluation, my conclusion would be different because of this new research and all of that. Or if this guy just thinks that this person will work out for them and is going to bat to try and get somebody different. And maybe if they don't work, they don't present this defense. I just don't know the status of it. So I agree with what you're saying, and I don't know what has happened. He couldn't get enough oxygen, was overcome by CO2. I don't know if it was that or if it was positional asphyxiation. In other words, the suitcase is not necessarily, obviously not airtight. Doesn't mean it didn't restrict his oxygen flow too much, but it also, I think, was a position that he was in. Eventually, he lost the ability to keep breathing under the circumstances he was under. Maybe that. Yeah, I'm interested to see the revised letter. Well, that's what got me on this, was I was looking for it and found this situation. If anybody's tuned in new, this is the court document. Now I'm going to scroll it back up to the top of the relevant part in it, where there's an objection to appointing a mental health expert at $400 an hour because there already was a mental health expert appointed and spent, I think they said they paid $7,500 for the first mental health expert. So they're saying you already had one, and this new one is twice the rate. So you only should get one in the first place, and you definitely don't need another one that costs twice as much. And her video proves reckless indifference. Looks like it to me. Looks like it to me. Here that a couple of jurors may have talked in the Brooks case. That's very interesting as well. And that there was some comment on the docket, I haven't looked at it yet, about Brooks, that maybe he wasn't even transported or presented by Zoom or whatever because of this. That would, I think, be because of the motion to dismiss, a motion to withdraw, which I think that's what bunged up his hearing this morning. Yeah, so the videos are terrible of this guy. They're out there on the internet where he's, you can see him move in the suitcase and she is having no sympathy and he's saying he can't breathe. And that goes on for a period of time because she makes 2 videos and then she goes upstairs and goes to sleep. And in the morning, he has expired. So they had a rough relationship. It involved a lot of alcohol and misbehavior, I think. But you play those kind of games, you may face some consequences, and that's what's going on right now. So that's the story on this. I will come back on the letter if that post up today and read it. But this to me is very interesting. Again, to conclude, in response to the defense request for a mental health expert, the agency that pays for that says, hey, you already had one and we paid $7,500 for it. You haven't shown why you deserve or need a second one. What happened? What was wrong with the first one? And then also the second one's way too expensive. So we'll see if her attorney responds to that. The hearing's supposed to be September 18th. And that's what I know on this. So we will shut this down and wait and see the letter. And we're actually ready for that whenever that occurs. That's it. And I think probably I'll talk to you guys later if the clerk gets that posted up. Well, that's it. Thanks. Bye.